Hey guys, welcome to my channel. This is the host with the Pet Legal Defense Fund. This case is coming to us from Florida. The facts surrounding this case are not really in dispute. In 2018, Deborah Thomas owned two dogs. One was a standard poodle and the other was a Portuguese water dog. She lived in a condo in Miami-Dade County. Her condo association had rules that prohibited her from having more than one dog. And also they had a size limit of 25 pounds for any dog that she would have. Both of these things were in her declaration of covenants, conditions and restrictions for her particular condo. So there's no ambiguity about what the rules were. The condo association sent her a letter saying, "Hey, you're violating the rules because you have two dogs." So she took steps to remedy that. She rehomed her standard poodle and then kept just her Portuguese water dog, which is under 25 pounds. So technically she was in compliance with the rules, but then she got a second dog. Again, a dog under 25 pounds, and she was once again in violation of the rules. She received another warning letter from the condo association threatening her with fines. But rather than rehoming a dog, she sued the association. She said that this rule prohibiting her from having two dogs violated her fair housing rights. There was nothing in the lease agreement or any other document that said that she could not have service animals. And she claimed that she needed both of these dogs to be her service animals because she suffered from severe depression and anxiety. The trial court agreed with her and issued an injunction against the HOA, prohibiting them from enforcing their rules against her. The trial court also made a ruling in her favor on the issue of attorney's fees. Then the condo association appealed that decision. Now we go up to the appellate court. They review the issue of whether or not the trial court erred in granting that injunction in favor of Ms. Thomas. The appellate court says, no, the trial court did not err. You can't prohibit someone from having two service animals if they need them. They point out that the Americans with Disabilities Act and the Fair Housing Act both require that people with disabilities be allowed to have the number of service animals that they need. So here's what we're going to be talking about in this video. We're going to talk about what happens when you're in a situation where you have a rule that prohibits you from having certain numbers of pets or certain types of pets, and your neighbor has a disability and they need a service animal. And we're going to talk about what type of rules condo associations and homeowners associations can and cannot do when it comes to service animals. Now let's go back to our case. Once the appellate court ruled in favor of Ms. Thomas, the matter went back down to the trial court. The trial court had to determine how much money the HOA had to pay her for attorney's fees, and she requested almost $39,000 in attorney's fees. But while all that was pending, the association filed an appeal on the issue of attorney's fees. And again, the appellate court said, you can't do that. You can't appeal an order for attorney's fees until you've paid them. So the appeal of the attorney's fees issue was dismissed, and then the matter went back down to the trial court. Ms. Thomas argued that the amount of the attorney's fees that the trial court awarded her should be increased because her attorney actually spent more than twice the amount of time working on this case than what the trial court used to calculate his fees. In opposition, the association said, no, you don't get to double dip. The fact that the attorney spent twice as long as he expected to spend does not allow you to get more attorney's fees. Well, the trial court reviewed those arguments and issued an order increasing her attorney's fees by a little bit over $16,000, bringing the total attorney's fees that the association had to pay her to about $24,000. The association was not happy about this. They said, I don't want to pay $24,000 in attorney's fees. Why are we paying so much money? Well, the reason is because you did not do the right thing in the first place. If you had not tried to fine her and evict her for having two service animals, then you wouldn't be paying $24,000 in attorney's fees. And that brings us up to the current appeal. The condo association is appealing the award of attorney's fees. They're saying, We shouldn't have to pay this much money, and Ms. Thomas is defending the award of attorney's fees. So let's take a look at the issues that are presented to us in this appeal. First issue is whether or not the trial court erred in awarding attorney's fees based on the actual hours that were expended by the attorney times the lodestar amount. The Condo Association argues that the trial court should have capped the amount of attorney's fees that it had to pay based on the number of hours that the court found were reasonably expended on the case. The reasonable number of hours, according to the trial court, was about 30 hours. They said even though the attorney actually spent more than 60 hours on the case, he wasn't going to be compensated for the additional hours because they were not reasonably expended. When it comes to attorney fee awards in Florida, courts use something called the lodestar method. Under the lodestar method, you first determine the number of hours that were reasonably expended by counsel on the case, and then you multiply that by a reasonable hourly rate. So the trial court said, okay, 30 hours times the reasonable hourly rate that I find is appropriate. That's how they came up with the initial number. Then they added 20 hours for the work that was done on the attorney's fee issue and multiplied that by the hourly rate that they set. That's how they came up with the new number. The Condo Association claims that the trial court should have just capped it at the initial number that they came up with, even though the attorney spent more than twice as much time as he initially anticipated spending on the case. The Condo Association also argues that the trial court erred in finding that the attorney spent only 30 hours on the case. They said no, he actually spent more than 60 hours on the case, and we should cap the attorney's fees at the number of hours that he spent times the reasonable hourly rate. The association also says that the trial court erred in determining the reasonable hourly rate. The trial court said that the reasonable hourly rate was $350 per hour for this attorney. The attorney usually charges between $450 and $550 per hour, but the trial court said, okay, considering the experience of the attorney and all the circumstances surrounding this case, a reasonable hourly rate is $350. The association said, no, you shouldn't discount his rate. He should be able to charge his normal rate, which is between $450 and $550. Let's see how the appellate court ruled on these issues. First, the appellate court ruled on the issue of whether or not the trial court should have capped the attorney's fees at the initial number that they came up with. The appellate court said, no, the trial court was within its discretion in awarding attorney's fees based on the actual hours that were expended by counsel, even though the hours exceeded what was initially anticipated. They said, the party seeking to recover attorney's fees has the burden of proving the amount of the fees, but the burden is not an onerous one. The party opposing the fees has the burden of showing that the hours claimed are unreasonable. The association failed to meet that burden, so the appellate court rejected that argument. Next, the appellate court addressed the issue of whether or not the trial court erred in determining that the attorney spent 30 hours on the case. The appellate court said, we review the trial court's factual findings on attorney's fees for competent, substantial evidence. The trial court here made specific factual findings on the hours that were reasonably expended, and we find that those findings are supported by competent, substantial evidence, so we will not disturb them. Finally, the appellate court addressed the issue of whether or not the trial court erred in setting the reasonable hourly rate. The appellate court said, we review the trial court's determination of a reasonable hourly rate for attorneys' fees under the abuse of discretion standard. The trial court here considered all relevant factors, including the experience and reputation of the attorney, the complexity of the case, and the amount of money at stake. And we find that the trial court's determination of a reasonable hourly rate was not an abuse of discretion. It may have been an erroneous, but it was not an abuse of discretion. For these reasons, the appellate court affirmed the award of attorneys' fees. So there are some interesting issues that come up when you have rules that restrict the number of pets that you can have, or the type of pets that you can have. If you have a person who needs a service animal and you try to enforce your rules against them, you could be looking at a lot of money at the end of the day. One thing that you might want to do, if you think that there's a potential issue with someone in your community, is contact your local fair housing agency and ask them whether or not the person that you're thinking about restricting or fining is protected under the law. It costs you nothing, and it may save you a lot of headaches down the road. Also, if you want to learn more about service animals, check out the Americans with Disabilities Act website, which is ADA.gov. They have a lot of great resources on their website about service animals. So thanks for watching. I hope you learned something in this video. If you have any questions about this case or any other case, feel free to contact me. If you like this video, please give it a thumbs up. You can share it with your friends and subscribe to the channel so you get notified every time we post a new video.